Imagine showing up to pick up a car you just paid good money for, only to find the words "no keys" painted directly onto the windshield. Not a sticky note, not a handwritten sign someone taped up. Painted, right there on the glass for everyone to see, except for you, the person who actually bought the thing. And to make it worse, the battery is so corroded, it looks like it came out of a shipwreck, and the grille that was clearly visible in the listing photos? Gone, completely gone. Oh, and you have until tomorrow to get it out of there, or you lose every single dollar you spent. That is exactly what happened to one car buyer in North Carolina, and their story raises some serious questions about what as is actually means under the law, and whether an auction house can simply lie to your face and hide behind fine print. Stick around, because by the end of this video, you are going to understand exactly what legal protections exist in situations like this, what steps you should take if it ever happens to you, and why the phrase "sold as is, no refunds" is not always the ironclad shield that sellers want you to think it is. So let us set the scene here. Online vehicle auctions have exploded in popularity over the last several years. The idea is simple. Browse listings from your phone or computer, place a bid, win the auction, and go pick up your vehicle. It is fast, it is convenient, and it can feel like you are getting a deal. But that convenience comes with serious risks, especially when you are buying something you cannot physically inspect beforehand. In North Carolina, like most states, vehicle auctions, particularly for used or salvage vehicles, often operate under what is called an as-is policy. That means the seller is telling you up front, what you see is what you get, and we are not responsible for anything wrong with this vehicle after the sale. No warranty, no returns, no refunds. And a lot of buyers accept that risk. You might be getting a project car, something that needs work, maybe even something that does not run. That is part of the gamble, and most experienced auction buyers understand that going in. But here's the critical thing that people often misunderstand about as-is sales. As-is does not mean the seller has the right to actively lie to you. There is a massive legal difference between failing to disclose a defect and outright misrepresenting the condition of a product. One is a risk you accept. The other is fraud. And that distinction is exactly what sits at the heart of this story. Our buyer in North Carolina found a vehicle listed through a local online auction. The listing was straightforward enough. It described the car as one that runs and has keys. There were photos included, and in those photos, the car had a grille. Nothing in the listing suggested this vehicle was missing major components or that it was completely inoperable. Based on that information, our buyer placed a bid and won the car for $725. Not a huge sum in the grand scheme of things, but real money that anyone would want to protect. Now, because this was an auction pickup, the buyer did not get to physically inspect the vehicle before bidding. That is common with these online auction formats. You bid based on the photos and the written description, and then you go pick up after you win. So our buyer shows up, ready to take their new vehicle home, and that is when everything falls apart. The first thing they notice is writing on the windshield. Painted on, in what appears to be permanent paint or shoe polish, are the words, "No keys." Not hidden, not subtle, right there on the glass. This is not a small detail. A vehicle without keys is not just an inconvenience. It means the car cannot be started in any conventional way. It means you are potentially looking at a locksmith, a new ignition system, or a complete key replacement, all of which cost real money on top of what you already paid. Then they pop the hood, or maybe just take a look at the battery, and what they find is a battery so heavily corroded that the car would not have started even if the keys were there. We are talking serious corrosion, the kind that does not happen overnight. This battery had clearly been neglected for a long time, and anyone who had looked at this vehicle prior to listing it would have known about it. And yet the listing said the car runs. And if that was not enough, the grille that appeared in the listing photos, missing, not damaged, not cracked, gone. Someone had removed it between the time those photos were taken and the time our buyer showed up to collect the vehicle. Whether it was stolen, sold separately, or simply removed by the auction house or a previous viewer, the result is the same. The car our buyer saw online and the car sitting in front of them were not the same vehicle. Now our buyer is standing there in a parking lot, staring at a car they cannot drive, that is missing parts, that has no keys, with a ticking clock over their head. The auction terms state that if the vehicle is not removed by the following day, the auction house gets to keep the $725, and they owe the buyer nothing. So not only has this person been deceived, they are now under enormous time pressure with zero leverage. Our buyer did the smart thing and started asking questions. Can this be challenged legally? Does as is really cover outright lies? Can an auction house just describe a car as running and then hand you something that clearly has not run in months? These are exactly the right questions to be asking. Here's what the law actually says about this. In North Carolina and across the United States more broadly, as-is clauses in sales contracts are enforceable, but only up to a point. The legal concept that limits their power is called fraudulent misrepresentation. If a seller makes a false statement of fact, knows it is false, intends for the buyer to rely on it, and the buyer does rely on it and suffers damages as a result, that is fraud. And fraud voids contracts. It does not matter what the fine print says. You cannot contractually waive your right to not be defrauded. In this situation, the auction listing stated the car runs and has keys. Both of those statements appear to be false. The keys were missing. In fact, someone took the time to paint that information on the windshield, which suggests it was known well before the auction took place. The battery was so corroded the car could not have run, and the grille shown in the photos was no longer there. These are not minor discrepancies. These are material misrepresentations about the core functionality of the vehicle. North Carolina also has a law called the Unfair and Deceptive Trade Practices Act, sometimes called UDTPA. This is a powerful consumer protection statute that prohibits businesses from engaging in unfair or deceptive acts in commerce. What makes this law particularly potent is that if you win a claim under it, the court can award you treble damages, meaning 3 times your actual losses, plus attorney's fees. Even if our buyer is only out $725 directly, a successful UDTPA claim could result in a much larger judgment, which also makes it more attractive for an attorney to take the case on contingency. So what should our buyer actually do? First, document everything immediately. Take photos and videos of the car, the painted windshield, the corroded battery, the missing grille. Screenshot the original auction listing with the description and photos before they disappear. Save any emails, text messages, or communication with the auction house. This documentation is your evidence, and you need to preserve it before anything can be changed or deleted. Second, contact the auction house in writing. Email is best, and formally dispute the transaction. Reference the specific language in the listing and describe how the vehicle does not match that description. This creates a paper trail and may prompt them to resolve the issue without litigation. Third, file a complaint with the North Carolina Attorney General's Consumer Protection Division. This is free, it is relatively straightforward, and it puts the auction house on notice that a government agency is now aware of the situation. Businesses tend to take that seriously. Fourth, consult with a consumer protection attorney. Many offer free consultations, and given the UDTPA angle, an attorney might be willing to take this case with the expectation of recovering fees if you win. $725 might not feel worth suing over, but treble damages plus attorney's fees changes that math significantly. And fifth, and this applies to everyone watching, before you ever bid on a vehicle at auction, read the terms carefully, look for red flags and listings, and if at all possible, inspect the vehicle in person before bidding. If the auction does not allow pre-bid inspection, factor that risk into how much you are willing to pay. Here's the bottom line. As is means you accept the risk of unknown defects. It does not mean you accept being lied to. There is a legal line between a hard sale and a fraudulent one, and from everything in this situation, that line appears to have been crossed. If something like this has happened to you, if you have been sold something based on false descriptions, or an as-is contract was used to cover up outright deception, do not assume you have no options. Talk to a consumer protection attorney. Document everything. File complaints with your state attorney general. The law exists to protect you, and fine print does not erase fraud. If you found this video helpful, please subscribe to this channel. We cover real legal situations, just like this one, every week, breaking down what the law actually says and what you can do to protect yourself. Hit the notification bell so you never miss an episode, and if you know someone who has dealt with a shady auction sale or a deceptive seller, share this video with them. It might be exactly what they need to hear.